Hey everyone, I'm attorney Justin Lovely. I'm here with another episode of the Carolina Justice Report videocast and podcast. I'm here with my associate attorney John Paul Simkovich. We call him JP. You can call him John Paul or JP. And we're going to be having another discussion, like we have been, on some legal topics that are of some interest to our audience here. Today we're going to talk about premises liability cases. Those are big here at the beach and down in Charleston. And it's really an encompassing area of the law. A lot of different topics we can talk about. We're going to touch on some of the big points and just have a discussion and kind of educate our viewers. If you like this video, again, I ask you on every video or podcast, like and follow us on TikTok, Instagram, Facebook, of course, or our website, wherever you consume your media. So John Paul, what's going on today, man?
Yeah, feeling good.
Cool deal. Let's keep talking here. Let's talk about this premises liability. And we see a lot of slip and falls here with the hotels. We got a lot of hotels here at the beach and down in Charleston, big tourism area. Obviously when the rush is, we're getting down towards the end of the rush because the summer season's over.
Yeah.
So the phone calls will slow down, but we're still getting them coming in. And it could be a hotel, the amusement parks, rental homes.
Mm-hmm.
Just briefly, give me your definition of what you think premises liability law is in South Carolina.
Yeah, premises liability law in South Carolina is essentially whenever anyone's invited to their property, whether or not it's over to someone's home or you're going to visit a business, maybe you're going shopping, you're at a grocery store, you're renting a condo at a resort here in Myrtle Beach or down in Charleston, and you're injured because the property owner, whoever's in charge of maintaining the property, didn't alarm you or alert you to a defect that created your injury.
Yeah.
That's kind of a legalese way to say it, but essentially, there was a danger. They knew there was a danger, or should have known there was a danger, and because of that, you got injured.
Yeah, and so that's a lot of the bigger cases in our office are these slip and fall cases.
Yeah.
The good news is we're usually dealing with like a corporate defendant who has good insurance. Usually we're dealing with $1 million policies. So unlike a car wreck where sometimes there's only a minimum of $25,000, we're dealing with a 7-figure policy. So that's a good thing about them. But yeah, you're right. It's anything. And just, I mentioned hotels just because we got a lot of that with the tourists that get down here, and they'll slip and fall at a pool, for instance, or maybe at a restaurant, anything. Let's say that, a property owner's down here and they know there's something. Let's just use the hotel for an example.
Okay.
Let's say there's a dangerous condition. Let's say there's something wrong with maybe some tiles at the pool,
Okay.
and they've had some complaints. How soon should that owner, now that he knows about this dangerous condition, repair that?
Well, in an ideal world, immediately. They really are given kind of a reasonable time. What reasonable is different to everyone else.
Yeah.
But they're under an absolute obligation. If they know that someone had been injured there, if they can't fix it immediately, they need to coordinate or, block it off, make a sign, highlight it in bright orange tape, do something to make sure that no one else also suffers the same injury.
Right.
So they need to take those steps immediately.
And something that we saw with COVID is down here at the beach, it was so hard to rehire people. And so what they were doing, they didn't have maintenance men, they didn't have staff, right? So these hotels, these resorts, even restaurants are understaffed. They had these known issues. People are getting hurt. They just didn't have the time or resources to go back and repair these. And they were on notice. So, and it's bad for the tourists who got hurt, but it's actually good for their case because it's all documented now. But that was a big problem with the tourism industry. People may or may not know this about Myrtle Beach, but there's the J1 students that come over from overseas really run probably 30% of that staffing. So that's something that's popped up, and we've been able to get some cases out of it just because there's so many more issues happening.
Yeah, it's scary.
Yeah,
When you
it's
think
real.
about it. One classic law school example is they say you're shopping at a grocery store and a banana peel's on the floor. Well, I know you don't see people actually slip on banana peels anymore, but if that banana peel is brown, that means that a lot of time has transpired and that store should have done some kind of sweep, found it, removed it, and stopped someone from slipping on it.
Right.
If it was almost green and yellow, then maybe it hasn't been there as long. So they need to take reasonable steps into secure it and make sure that it's a safe condition as soon as possible.
Right. And using that example, or a hotel or any premises, really video surveillance that our team digs in, our investigation team, and then us through discovery, that can really turn the case. And that will usually not be produced to us unless we file a lawsuit.
Absolutely. And, prior incident reports, if we can find out that they knew this was a dangerous condition, the first thing we hear is this was open and obvious. People could see this raised cement piece of cement. They could see the dip in the floor. They should have never walked there. But when we can show that the hotel has had other people get injured, we can prove that they were on notice that this was dangerous.
Right.
And that helps the case tremendously.
And many people will come down here on vacation. They get hurt. They may go to the ER down here, or may not, or they'll try to just rough it out because they're on vacation. Then they go home and realize, well, I'm really hurt. I got a slit disc. I got a torn MCL, whatever it is. And they may have gave their information to the premise owner, but they're getting ghosted. There's no phone calls from an adjuster, or they get a phone call. They try to get them to give a recorded statement, right, which is going to be used against them later. It's totally ridiculous. And then it's just like a zero offer. They're not going to do anything. So what do you say to those people? There's really only one thing they need to do.
They need to hire an attorney.
Absolutely.
I mean, with cases like this, you almost have to file suit 100% of the time. There's really no settling before a lawsuit, unfortunately. They need to know that you're serious and you have the expertise. When we get hired, we're going to send people to document the scene, send preservation letters. So if there was a video of the incident, we make sure that hotel, that resort, that landowner doesn't destroy that video because we want to see it. It's going to be evidence in the case. But all too often, these videos get written over. They're on a loop, and if we wait 3-6 months, then I can almost guarantee you that video has been destroyed. And they can kind of wiggle out of it and say, well, that's our standard course of business. So if we get involved, we sign up the client, they sign with us. We're going to send those preservation letters out immediately, make sure that all the evidence that we need is preserved so we can actually pursue the case and win the case.
Yeah. And remember, the insurance adjuster is not working. Let me just talk to the camera. They're not working for you, okay? They have unlimited resources. They don't want to pay you anything. And they're taking your statement simply to deny, delay, devalue your claim. You've heard me say the 3Ds several times. And also, when you're giving a statement, you might be jacked up on adrenaline because you just got hurt. You just got back off vacation usually, or whatever the case may be, and you're not really accurately talking. And so never give a statement. Don't do that. If you ever have to give a statement, it'll be with JP or me standing beside you at a deposition. And you spoke on the need to litigate. Some clients are kind of timid about that, but there's really nothing that they need to do. That's the heavy lifting's on us. They'll have to give a deposition. Do you want to just touch on that?
Yeah. So, I mean, the heavy lifting's all done by us, kind of behind the scenes. We're going to be, once we get involved and we do have to file a lawsuit, the landowner and the insurance company is going to hire a defense attorney. So we're going to be dealing with them. What we would need from our clients is just a clear and accurate record of how it happened. The actual facts of how their injury occurred is vital. So then we find out where they treated because we want to get their medical records and, make that good documentation of what their injuries have, what they've gone through and how the injury occurred. And other than that, maybe participating in a deposition, which is just coming into our office in a similar room like this and just telling the truth. Yeah. They'll be asked about it. You or I will be next to them to protect their rights. We'll object if we need to, but they just need to tell the honest truth, explain how it happened and how it's really, turned their life upside down. From there, we can kind of take it all the way to trial, and then maybe they would have to participate in trial if it reached that point. But the majority of the time, it will be just their involvement of telling us the facts and letting us argue on their behalf.
Yeah. The biggest thing, and we always tell this when a new client signs, is let us worry about all the legal issues, the adjuster, everything. You worry. Just talk to our medical staff and our paralegals. But as a client, you worry about going to the doctor, get to feeling better,
Absolutely,
and follow the doctor's orders. Okay, that's another big thing.
That's their primary job.
Absolutely. So let's just touch base on a lot of these cases, it's not like a car wreck where they're going to settle pre-lit. Rare is the premises liability case that settles pre-litigation. And the big issue touched on this too is the notice requirement. But the other issue that we normally have is we just can't give, if it's like you said, if there's a raised piece of concrete, if there's a building code violation, we can't just say that as the lowly law firm. We're going to have to retain an expert. Okay.
Yes.
And, we have a network with the best experts for premises cases in South Carolina. Sometimes we go out of state to pull them in, but just touch on that base, the need to have an expert to give us an opinion.
Yeah, absolutely. So, I can look at a piece of raised concrete that you tripped over and yell till the day is long that this was a dangerous condition and that my client deserves compensation. But we need an engineer, a human factors expert, someone that has actually done the testing and can opine to the reasons why this is a dangerous condition, why this we have building codes. We have building codes for a reason,
Right.
and that's for the safety of everyone that's going to be on that property. And we need an expert to testify and explain why this building code was violated and what they could have done to remedy this dangerous condition. So the expert's opinion will carry a lot of the weight when we're making arguments. We use their opinions to make arguments, and they're supporting it. Like you said, we work with experts all the time. Have their numbers in our cell phones.
Yeah.
Pull them from out of state. We were just talking earlier about experts in Colorado and Illinois, and we'll find them if we need them. And a lot of times with a premises case, almost every time we need them.
Yeah, and it costs money. That's not cheap. But we have the resources here that we can retain them and let them use their expertise to work up the case to add value. Because the slam dunk that we want is that building code violation, right?
Yes, that's the best thing we can have.
If we hear that, it's great. We're arguing over damages, not liability.
Exactly.
Because they'll try to beat these cases on liability. And if we don't have the damages to support it, it's not going to justify the attorney's fees and costs. And we're up front with the client, once we do an intake and do an analysis of their case facts.
Hiring an expert isn't cheap. But that's why you want to come to a firm that's been well established and can actually put forth the money to hire the experts. So we have an opinion. I always tell my clients, we're going to act like we're going to go to trial. We're hopeful that we can get it resolved without having to go to trial, but we're going to prepare every case like we're going to see the inside of a courtroom. And so you need that expert opinion, and we have the resources to retain them and hire them and, talk to them and do everything we need to. So we can present everything to the insurance company, that landowner, and say, look, this is why your goose is cooked.
Yeah. The other thing about you touched on this earlier about getting an attorney early. So
yes.
You need to get to an attorney early, but you also need to get to an attorney who knows the experts, because guess who's getting to these experts before we do? The defense, right?
Yeah.
And if they hire them, we got to go start searching for somebody else who's going to give a differing opinion. Of course, that's not usually the experts that we would retain. It just depends on the facts.
Sure.
But some of these are hired guns who might get to it before we do, and they give an opinion that's not going to be favorable for the client.
And the other reason you want to retain an attorney immediately is you might have a dangerous condition, and the landowner knows that raised piece of concrete, that huge piece of the pothole, the area in the sidewalk that's collecting water and creating slippery conditions. They realize you got hurt there, so they're going to fix it as soon as possible. And then when we go back to the scene to try and point to it and say, look, jury, this is the condition, it's not there anymore.
Right.
So you need to hire an attorney quickly so we can get someone out there. You have a great network of investigators that will go there, trained, and they can document the scene. So we have the pictures, and then we can have our expert rely on the photos if the landowner goes back and corrects a dangerous condition that they knew was already there.
And a great takeaway from that statement is just, if you're hurt, try to take pictures. We tell this to clients. You're surprised how many people they're swept away, of course, to the ER by ambulance. They forget to take pictures. But if you're down here on vacation and a family member falls or you fall, get that cell phone out, take everything you got, because that will help us, especially the fact that you just described if they go and fix it. It's an uphill battle.
It is. So document it, take those photos. If you're in the ambulance in the hospital, get a loved one to do it, whatever you can.
Well, we can talk till we're blue in the face about this. There's different rabbit holes that we can go down, because we can talk about restaurants and how those are different, how hotels are different, how pools are different, and we will, but not in this episode. So that's going to be enough for today with the Carolina Justice Report. Again, I'm attorney Justin Lovely. This was John Paul Simkovich. If you have any issues related to a slip and fall or any kind of premises case that you may have, reach out to us. We'll talk to you for free. We'll let you know our opinion if we think it's something we can pursue for you. Again, if you like this, reach out to us on social media. Follow us on TikTok, Instagram, Facebook, wherever you consume. We're over and out, and see us on the next episode.